Imagine a director obtaining a valid DIN, entering the boardroom of multiple companies, approving financial statements, signing resolutions, participating in mergers, and influencing investor money. But the companies themselves fail to inform the registrar of companies about that DIN. Now imagine regulators discovering incomplete director records, hidden governance structures, compliance gaps, and broken transparency systems. Suddenly, what looked like a simple filing omission becomes a serious governance failure capable of triggering ROC scrutiny, secretarial audit qualifications, investor distrust, and compliance penalties. This is exactly why Section 156 of the Companies Act 2013 becomes one of the most underrated yet critically important governance transparency provisions in corporate law. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today we are entering deep into Section 156 of the Companies Act 2013, the provision dealing with intimation of director identification number by the director to the company. At first glance, many students treat this section as a tiny procedural requirement. But experienced corporate governance professionals know that Section 156 acts like a vital communication bridge connecting directors with corporate regulatory systems. Without this communication chain, the DIN framework itself becomes incomplete. Section 153 creates obligation to apply for DIN. Section 154 governs allotment of DIN. Section 155 prohibits multiple DINs. And Section 156 creates the legal obligation requiring the director to intimate the DIN to every company in which the person acts as director. This integrated structure creates a complete governance identification ecosystem. Now let us understand the legislative intent behind this provision. The government wanted not only centralized identification of directors, but also accurate corporate level governance records. If companies do not receive proper DIN information from directors, registrar filings, board records, annual returns, and governance disclosures become unreliable. This directly affects transparency and accountability. Section 156 therefore ensures that governance identity information flows properly from the individual director into corporate records. The provision states that every existing director shall within 1 month from receipt of DIN from the central government intimate such DIN to all companies wherein he is a director. This sentence appears simple, but every part carries practical importance. The phrase every existing director means this obligation applies broadly across directorship structures. The phrase within 1 month creates a statutory timeline, and the phrase all companies wherein he is a director expands the obligation across every corporate position held by that individual. Now think practically. Imagine a director serving on the boards of 10 companies. Once DIN is allotted, the law expects that director to communicate the DIN to every one of those companies. Why? Because each company must maintain accurate governance records and subsequently file correct information with ROC. This creates synchronized governance transparency. Another important insight is that Section 156 places responsibility directly upon the individual director. This is extremely important from governance perspective. The law does not merely expect companies to discover director details independently. It imposes an affirmative legal duty on directors themselves. This reinforces accountability. Now let us discuss the practical mechanism. After DIN allotment under Section 154, the director generally communicates DIN details formally to the company. This communication should ideally occur through proper written intimation supported by documentary proof. Good governance practice demands maintaining proper records of such intimation. Company secretaries generally preserve these records carefully because they become important during audits, inspections, and due diligence reviews. Another important practical area relates to timing. The 1 month timeline is extremely important. Many professionals ignore statutory timelines, assuming DIN compliance becomes complete merely upon allotment. That assumption is dangerous. Section 156 creates a separate continuing compliance obligation. Failure to intimate DIN timely may trigger compliance exposure and governance concerns. Now let us connect this provision with Section 157. After receiving DIN intimation from the director, the company itself must furnish those details to the Registrar of Companies within prescribed timelines. This means Section 156 and Section 157 operate sequentially. Director informs company, company informs ROC. This creates a complete regulatory information chain. Students frequently confuse these sections during examinations. Understanding the sequence is extremely important. Another governance insight relates to board transparency. If directors fail to intimate DIN properly, companies may unknowingly maintain incomplete or inaccurate governance records. This affects statutory registers, filings, and public disclosures. For listed companies, this can become highly sensitive because governance disclosures directly influence investor confidence. Now let us discuss practical secretarial compliance. Whenever a new director obtains DIN, the company secretary should immediately verify the following: whether DIN allotment confirmation exists, whether intimation has been received formally, whether supporting records match MCA data, whether board records and statutory registers require updating, whether ROC filings under Section 157 are triggered. This proactive governance approach prevents future compliance defects. Another hidden practical issue involves resignation and multiple directorships. A director may assume that informing one company is sufficient. That assumption is incorrect. The law requires intimation to every company where the individual acts as director. Missing one company creates incomplete governance disclosure. Now consider a real corporate illustration. Imagine a professional director serving across several listed and unlisted entities. The director obtains DIN and informs only major listed companies but overlooks smaller group entities. Years later, during due diligence for acquisition, inconsistencies emerge between MCA records and internal company records. Investigators question governance discipline. Secretarial audit observations arise. This demonstrates how seemingly small procedural gaps can create larger governance concerns. Another important governance aspect involves digital compliance systems. Modern MCA governance frameworks depend heavily on accurate director databases. Sections 156 and 157 help maintain synchronization between individual identity records and corporate records. Without this synchronization, regulatory oversight weakens. Another practical challenge arises in startups and family-managed businesses. Promoters often focus heavily on commercial growth while neglecting governance formalities. Intimation requirements get ignored casually. Later, when investors conduct due diligence, these governance gaps surface unexpectedly. Strong compliance culture from the beginning, therefore, becomes extremely important. Now let us discuss applicability across company categories. Section 156 applies broadly because DIN compliance connects with director identity itself. Whether private company, public company, listed entity, OPC, or dormant company, directors holding DIN must comply with statutory obligations wherever applicable. However, governance impact becomes particularly significant in listed companies because public investor trust depends upon accurate disclosures. Another important practical concept relates to documentation. Professionals should maintain proof of DIN intimation carefully. Good governance practice may include written communication, acknowledgement records, and digital tracking. Absence of documentation creates evidentiary weakness during inspections or disputes. Now let us discuss board meeting implications. Whenever new directors join boards, governance teams should ensure DIN verification and proper record updating before finalizing filings. Board minutes should accurately record DIN details where relevant. Incorrect or missing DIN references can later create ROC filing inconsistencies. Another hidden exam trap involves misunderstanding the role of the company. Section 156 imposes obligation on the director. Section 157 imposes obligation on the company. Students frequently interchange these responsibilities. This distinction is crucial for professional examinations and practical advisory work. Now, consider investor protection perspectives. Accurate director identification improves confidence in corporate disclosures. Investors want transparency regarding who controls corporate decisions. When governance records remain inconsistent or incomplete, suspicion naturally increases. Section 156 indirectly strengthens market confidence by supporting accurate governance disclosure chains. Another important governance insight relates to fraud prevention. If directors fail to intimate DINs properly, companies may maintain fragmented governance records. This weakens traceability and regulatory oversight. The law therefore ensures that identity information flows properly into every company structure. Now let us connect Section 156 with secretarial audit frameworks. Secretarial auditors verify director details, DIN status, and compliance documentation carefully. Failure to maintain proper DIN intimation records may attract audit observations. For listed entities, governance observations can significantly affect market perception. This demonstrates the practical importance of even seemingly minor procedural provisions. Another practical issue involves foreign directors. Foreign nationals serving as directors in Indian companies must also comply with DIN-related obligations. Cross-border governance structures therefore require careful coordination between legal teams, compliance officers, and company secretaries. Now consider interaction with Securities and Exchange Board of India governance frameworks. Listed entities make extensive disclosures regarding board composition, director profiles, and governance structures. Accurate DIN records support these disclosures. Errors or inconsistencies can create regulatory concerns under securities law as well. Another important professional practice tip is maintaining updated governance databases internally. Companies should periodically reconcile internal director records with MCA records to identify inconsistencies early. Preventive governance is always safer than corrective governance. Now let us discuss consequences of non-compliance. While Section 156 itself appears procedural, governance failures can trigger broader compliance exposure under the Companies Act. Incorrect records may affect filings, disclosures, and regulatory credibility. In serious situations involving concealment or manipulation, wider legal implications may arise. This is why governance professionals never treat DIN compliance casually. Another hidden practical challenge arises during mergers and acquisitions. Acquirers conduct detailed governance due diligence, including director identity verification. Missing DIN intimations or inconsistent records create governance red flags. This may delay transactions or increase compliance scrutiny. Another governance insight relates to corporate culture. Companies with weak compliance discipline in small procedural matters often demonstrate broader governance weaknesses elsewhere. Therefore, professional investors and auditors often examine how seriously companies treat statutory compliance obligations. Now, let us discuss judicial and legal interpretation perspectives. Courts and regulators increasingly emphasize substance and transparency in governance compliance. Accurate director identification is considered fundamental to modern corporate regulation. Therefore, companies and directors should avoid treating DIN compliance as mere technical formality. Another practical observation involves independent directors. Independent directors especially should maintain meticulous governance compliance because their credibility depends heavily upon transparency and regulatory discipline. Incomplete DIN communication records may undermine governance confidence unnecessarily. Now let us connect this provision with anti-money laundering and forensic governance frameworks. Centralized director identification systems help authorities trace corporate networks, related parties, and governance connections. Section 156 supports this broader ecosystem by ensuring companies themselves possess accurate director identity data. This strengthens regulatory traceability significantly. Another important practical area involves resignation and cessation updates. Even after directors resign, historical governance records linked with DIN remain important for investigations, audits, and due diligence. Therefore, maintaining accurate DIN communication history matters long beyond the initial appointment stage. Now consider the role of company secretaries in greater depth. The company secretary acts as governance gatekeeper. This includes verifying DIN compliance, maintaining statutory records, coordinating filings, and ensuring regulatory synchronization. Failure in these functions can create substantial governance complications for companies. Advocates often become involved when governance defects trigger disputes or investigations. Chartered accountants and cost accountants examine governance consistency during audits and compliance reviews. This demonstrates how Section 156 affects multiple professional domains. Another hidden governance lesson emerges here. Modern corporate law increasingly operates through interconnected digital compliance systems. A small procedural failure in identity communication can create ripple effects across filings, disclosures, and governance databases. Attention to detail therefore becomes critical in corporate practice. Another important practical insight is that governance transparency is cumulative. Investor confidence does not arise from one major compliance action alone. It emerges from consistent discipline across hundreds of seemingly small governance requirements. Section 156 represents one such critical discipline mechanism. Now let us think about the broader policy philosophy. Corporate power should never operate invisibly. Every director participating in management should remain traceable within both government systems and company records. Section 156 operationalizes this philosophy at company level. As we conclude this deep masterclass discussion, remember one powerful insight. Section 156 is not merely about informing a number. It is about connecting directors with corporate governance transparency systems. The law ensures that every company knows exactly who its directors are from a regulatory identity perspective. This strengthens accountability. This improves filings. This supports investor confidence. This enhances regulatory traceability. and this protects the integrity of India's corporate governance architecture. For company secretaries, Section 156 represents an essential governance coordination responsibility. For advocates, it becomes relevant during governance disputes and compliance investigations. For chartered accountants and cost accountants, it supports audit reliability and disclosure accuracy. For investors, it strengthens trust in governance records. For regulators, it improves enforcement efficiency. And for corporate India itself, Section 156 remains one of the important transparency provisions, ensuring that director identity information flows accurately across the entire corporate regulatory ecosystem. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.